Are the parties ready? Okay, we'll start with a sound check. This is the case of Iowa Association of Business versus City of Waterloo. We'll start with Mr. Bowler. If you wanted to give a sound check, you'll need to turn your mic on.
Sound check.
Yes, thank you, Counsel. I can hear you just fine.
Thank you. And then Mr. Koopmans, if you'd like to do the same, and then you can begin when you're ready.
Good afternoon.
Thank you. I can hear you fine, Counsel.
Thank you. Chief Justice, may it please the court. In 2017, the legislature decided that it wanted greater statewide uniformity when it came to the employment-employer relationship. It did that through an express preemption statute that governed hiring practices, among other things, in what has now become Iowa Code Section 364.3, sub 12. In relevant part, the statute states that a city's regulation of hiring practices cannot exceed the regulation of hiring practices.
Oh, but you're skipping over, Counsel. It says any terms or conditions of employment. So the hiring practice has to be a term or condition of employment under the statute, does it not?
Yes, it does, Your Honor, but terms and conditions of employment under the statute encompasses hiring practices, as the later clause makes clear.
I don't see how that follows. Just reading from the text. Any terms or conditions of employment that exceed or conflict with the requirements of federal state law. And then it has hiring practices in the list or other terms or conditions of employment. So the term hiring practice is sandwiched between any terms or conditions of employment, both the front end and back end. Doesn't the language of the statute require that not all hiring practices are covered, but only those that amount to a terms or condition of employment? Is that we can't strike the other terms or conditions of employment from the front end and back end of the statute, I don't think.
No, you cannot, Your Honor. But the statute read in context does inform what hiring practices and terms and conditions of employment means in that context. So legislatures and Congress have used conditions of employment in different circumstances, as NAACP has pointed out. But in this particular context, hiring practices means nothing, almost nothing, if it does not include pre-employment activity. And therefore, the general hiring practices, as we would know those, must include the activity here. And in fact, Waterloo assumed that it does. And we know that the legislature has used that term before. For example, in Iowa Code Section 730.4 sub 2 states that an employer shall not use as a condition of employment, an employer shall not, as a condition of employment, request or require that an applicant for employment take or submit to a polygraph examination. No one would argue that that statute doesn't apply until the employer has offered that applicant a job. It says even if you never offer that applicant a job, you may not subject them to a polygraph examination. Similarly, Iowa Code Section 216.6, this is the Iowa Civil Rights Act, point 6, which is the unfair discrimination section, sub 1 sub D states that it shall be an unfair or discriminatory practice for any person to solicit or require as a condition of employment any prospective employee attest for the presence of the antibody to the human papilloma HIV virus. So again, the Iowa legislature has used condition of employment to be broader in terms of the hiring practices. And the hiring process in general itself, colloquially, is a condition of employment. If you do not go through that hiring process and those policies, you may not be employed.
Could we split the baby here, Mr. Koopmans? Is it possible to say that the actual hiring decision, that's a hiring practice, but to the extent that the ordinance prohibits asking about convictions or including a conviction inquiry on an application, to that extent, those are not terms and conditions of employment, including hiring practices, and those are not preempted?
I would say
split it that way?
No, Your Honor. I would say that given the statutes I just read you, which are more akin to asking about something on an application, subjecting someone to a polygraph test, asking them on their application about their criminal history, those are essentially the same kinds of application processes, subjecting them to different tests or asking them different things, as opposed to what the employer is considering. It is about what you are requiring the employee to give, what kind of information, whether that's your criminal history information or in the statutes I just read to you, your health information. So I don't think that there is anything in the statute that would suggest that kind of limitation.
Counsel, was the statute enacted just to cut off cities from raising the minimum wage?
No, Your Honor. It says minimum wage, and then, of course, it says many other things. So clearly, the legislature intended to do much more. The coverage, and I think perhaps the impetus of the statute, which we generally know of from that time period, was cities creating different minimum wages from the state minimum wage. The legislature then began to think about uniformity in broader context of the employer-employee relationship.
Can I discuss the interplay a little bit between the ICRA and the preemption statute? So if I understand your argument correctly, you would acknowledge the ICRA, maybe it doesn't allow, but it doesn't preclude municipalities from extending protection to broader categories of persons. Is that right?
Correct.
So, for example, Iowa City protects family status, which is not in the ICRA. So I take it your position would be, at least with respect to the things that are covered in 364.312, a municipality could not extend coverage to those additional categories of persons. Is that right? So, for example, Iowa City could not include family status as a protected category with respect to these terms and conditions of employment in 364.312. Is that right?
Correct. And because it is not an authorization because the Civil Rights Act, that provision 216.9 sub 1 is not an authorization, but simply a savings clause. And after we submitted our opening brief in this case, this court actually decided that very issue in slightly different context, but said that very same thing in Petro versus Palmer Chiropractic.
So, counsel, does that mean that this statute nullified the marital status ordinance in Iowa City that was at issue in Baker?
To the extent that it would apply to hiring practices, yes. And the legislature just recently, to give you just one more example, and I believe that Waterloo and the amici would say, well, if you're going to stop a city from enacting a broader practice, then you have to somehow reference the Iowa Civil Rights Act. That seems to be kind of the general take. Just a few weeks ago, the Iowa legislature passed another statute, Senate File 252, which is waiting for signature on the governor's desk or perhaps veto. But what the legislature said is a renter or a city cannot prevent a landlord from refusing to rent someone because they are paying for it with a Section 8 housing voucher. They did that very thing because some cities, including the city of Des Moines, have included source of income as a protected class under their discrimination statute. So if you were to somehow say that the Iowa Civil Rights Act must be addressed before the legislature can preempt these statutes, then that bill that the legislature just passed with this very specific purpose means absolutely nothing. And we know that others don't think it means anything because the cities themselves and the amici, in this case, NAACP and the ACLU, all registered against that bill and argued that it would expressly preempt those anti-discrimination provisions. So there is no, to kind of come back to the statute, the Iowa Civil Rights Act does not grant authority to do anything. So you have to find that power somewhere else. And there is no anti-discrimination exception to 364.3 sub 12. If it exceeds state or federal law in one of these listed categories, then it is expressly preempted. The district court, found two reasons. One was that the statute is not preempted. One is the Iowa Civil Rights Act savings clause, which we just talked about. The second, the district court said, and Waterloo argues, is that because it does not exceed state or federal law, and that is clearly wrong. On the first, there are five kind of substantive provisions of Ordinance 5522. The first two, as Justice Mansfield pointed out, dealing with inquiry into whether you can ask on an application or otherwise inquire or investigate about criminal history. The EEOC itself, in its own guidance, and I mean, this is in the case law, we do not have to get very deep, has said it is not illegal to do that. Ordinance 5522 makes it illegal to do that in all circumstances.
Well, but the ordinance permits, once a conditional decision has been made, the ordinance permits analysis of business necessity and criminal convictions, does it not? So the employer, in all cases, has the opportunity to evaluate criminal convictions and whether it relates to the job at hand, does it not?
It does, but when an employer does that, it's still a hiring practice that this ordinance regulates. Federal law does not regulate and allows an employer to do that at any point in the process. Therefore,
Well-
5522 exceeds state and federal law.
The process is different, no question about it. But the substantive application of law, if the question is, can an employer consider criminal convictions as part of the employment process and where there's reasonable business necessity and so forth? The answer to that question under this ordinance is yes. So the procedure is different, clearly, but isn't the requirement of federal law vindicated here?
I don't think the statute talks about kind of the purpose of federal law. I mean, so the statute says that you cannot regulate a hiring practice. A hiring practice in this case is you cannot ask on an application. Federal law says you can. Federal law says you can ask on an
Counsel,
application. Yes.
Actually, it doesn't say you cannot regulate. It says you cannot exceed or conflict. And that's where I go back to Justice Appel's question about the providing for any terms or conditions of employment that exceed or conflict with requirements of federal law.
Right, so
And
this
I'm-
ordinance would say that you have to provide an application that does not ask about criminal history.
So you're saying, so say that again.
You can say it in the positive or the negative. So the ordinance would say, if you're going to give an application, you have to give an application that does not ask about criminal history. That exceeds federal law, which does not have that prohibition.
And if you talked about conflict, I might agree with you. It's the exceed part. That brings back to mind probably the original purpose of this was minimum wage. You cannot exceed minimum wage. You cannot exceed the benefits that are allowed under state law. Those kind of things make sense. Using exceed in this manner doesn't make much sense to me.
I don't know how exceed conflict makes sense when you relate it to hiring practices in any kind of version of Your Honor's scenario. And I think
Agreed, and
to
that's
give
my-
this purpose, it has to have, and I think it is a natural reading of that, and otherwise the statute does not make
Yeah,
functional
and I
sense.
agree that the hiring practices is the ambiguous part of the statute. Because it doesn't make much sense when you're talking about terms or conditions, and especially when you read the rest of the list. But we do need to give some effect to hiring practices, and that's where I'm struggling.
The parties.
Well,
Yes, Your
I'm sorry,
Honor.
if you had an employment application that required you to waive all rights under the Iowa Civil Rights Act or under federal law, that would be a hiring practice that amounted to a term or condition of employment, and because it affects the job once one is hired, that would be a hiring practice that would be barred by the statute, would it not?
Say that again, Your Honor. So if the Iowa Civil Rights Act allows you to waive those provisions, which I don't know whether it does or not, then I think the answer is yes, if I was following your hypothetical. I don't know under Iowa law whether an employee can waive all of the Iowa Civil Rights Act provisions in an application. I don't believe that they can. So it would not.
Does this preempt, and I may be totally off base here, but does this legislation preempt efforts by cities to, on, say, public projects, require the use of a union contractor?
If it regulates the listed conditions, I guess, would be, can it enforce an ordinance, term or condition that exceeds or conflicts with requirements of state or federal law relating to minimum wage, any form of employment leave, hiring practices, employee benefits, scheduling practices, or other forms or conditions of employment?
A prevailing wage is often the way it's done, a prevailing wage on a public project, requirement that the contractor use prevailing wage. Is that preempted?
I do not know if you're talking about regulation of the employer or regulation of the city. And so I guess in this context, I don't know how all those things work together. So I really don't know the answer to your question, Your Honor. As you can see with all employment things, there gets to be layers upon layers upon layers. And when we deal with hiring practices specifically, I know of no limiting principle and no functional way to make this statute operate other than to say, which is the natural reading, that you cannot regulate, and I think that's the natural reading when you put all this together, you cannot regulate the hiring process to a greater degree than state or federal law. That's what the legislature intended. That's what Ordinance 5522 does, and therefore it is expressly preempted. Thank you.
Right on the dot. Thank you. Mr. Bowler.
Thank you, Your Honor. If it may please the court, good afternoon. To follow up on some of the points that Mr. Koopman raised, I want to direct the court's attention to what I think is really the central argument to be made here, and that is Section 216.191C expressly authorizes the city of Waterloo to do what they did in this ordinance. It says specifically in
But
that
Mr. Bowler,
statute.
I mean, I wrote the opinion, and it could be wrong, but right now it's out there, where I said that this is a savings clause. It's not an affirmative authorization. So how do you deal with that language from Petro?
Well, I don't think that's what Petro really actually stands for, Your Honor. What happened in Petro is just the opposite of what happened here. You had Section 364.1 that basically explicitly stated in no uncertain terms that cities could not regulate civil relationships, which of course is defined to mean they can't confer jurisdiction on courts over a local ordinance. In that situation, then the court searched through 216.19 to try to find an affirmative statement, which was a different type of home rule situation. In other words, because of that explicit preemption, the court then had to find something in 216 that explicitly said so. And because I think the savings clause you're talking about was another provision of that 216.19. It wasn't specifically 1C. As I recall, it was 216.19.8, which talked about getting letters to right to sue, and the court, I think, interpreted that as a savings clause. That's not really an issue here.
It was 1B, but so it was, you're right, it was a different provision, but the lead-in is the same language. Nothing in this chapter shall be construed as indicating.
Yeah, but
And implicitly what we were saying, or I think maybe explicitly what we were saying is that's just savings clause language. That isn't an affirmative authorization.
the nothing in this chapter language, of course, it was relevant in both Petro and here, but you have the additional language in subsection 216.191C. We have too many subsections in this case, I'm sorry, but we have to deal with it. Explicitly states, and I don't think there was anything like that in Petro, this is what the court was searching for. The city has the right to, local commission has the right to create broader or different categories
Well,
of
no, I'm
discriminatory
looking at the text of
practices.
the statute. It doesn't say that. It says, nothing in this chapter shall be construed as indicating any of the following, limiting a city or local government from enacting. It doesn't give it an affirmative grant of power to do that. I mean, you skipped the word limiting.
Yeah, but think about this, Your Honor. Aren't you saying then that we have to overrule Baker versus Iowa City? In other words, isn't that what Baker's all about? Baker said, in no uncertain terms, that the city of Iowa City could create this broader category of discriminatory practices, specifically marital status, which is not in the Iowa Civil Rights Act. And that, all I'm saying is that's precisely what the city of Waterloo is doing in this case.
Can I ask you a question about that? So, I mean, part of this is we have to remember, right, that the Iowa Civil Rights Act covers more than employment. So marital status applies to housing, fair credit, services and accommodations, education, et cetera. So, but here, I don't think anyone's denying the city can create new categories of protected statuses, but whatever it does under 364.3 or is preempted to the extent it's covered by 364.3.12,
Well,
right?
couple of responses to that. First of all, 364.312 does not expressly preempt what City of Waterloo did there. There's nothing in that statute that explicitly states a city shall not adopt an ordinance that regulates the consideration of criminal history in employment. Now, so there's no exception in 364, but isn't it the job of this court to construe the Iowa Civil Rights Act broadly? And the court has repeatedly stated that, which I think trumps 364.312 on that ground. But
Well, Mr. Koopmans points out to the hiring practice language in the statute, and he says, well, the Waterloo ordinance relates to hiring practices. It regulates applications and what you can ask in an application, what it doesn't, et cetera, and that the statute expressly says that hiring practices cannot exceed or conflict the requirements of federal law. He doesn't see terms and conditions of employment as meaning too much, I don't think, but the hiring practices is still there. How do you confront it?
Well, I go back to 216.191C that explicitly authorizes the action in this case. And then I say to myself, Your Honor, if you're correct, you're taking these two statutes and butting them right into each other. You're creating a conflict. And isn't that the job of the court to resolve those conflicts? So I'm telling, and obviously it's a basic principle of statutory construction, that we have to harmonize these two statutes. And so therefore, to the extent that is true, I think you can construe what's going on in the Iowa Civil Rights Act more broadly than what you do in 364.312.
Counsel, are any of the hiring practices that are at issue in the ordinance, would those be grounds for Title VII or Iowa Civil Rights Act claims on the basis of race discrimination? Disparate
Absolutely.
impact?
Absolutely.
Every single one?
I believe so, yes.
So does the ordinance do any work beyond Title VII or the Iowa Civil Rights Act?
Good question, Your Honor. Obviously, you ask good questions, but that's something I've thought about. I think what's going on here, you're absolutely correct. So why have the ordinance? Well, the ordinance attacks the same problem from a different angle. That's what's going on here, really. In other words, instead of utilizing a judicial process where an employer is held accountable and subject to thousands upon thousands of dollars in damages and attorney's fees, what we're trying to do is send the same signal citywide. In other words, you as an employer might not know that asking about criminal history on an application could cause a disparate impact or be discriminatory. Now you know, and now you're going to avoid doing that, and all we're doing is subjecting them to a $750 fine. It's really just a different way to attack the same problem. It's a legislative way, and doesn't that happen
Except
all the
with, I
time?
guess, to me, one exception, that you're imputing this liability to all of the employers within Waterloo, whereas in a Title VII or Civil Rights Act case, it's defendant by defendant. So if you're saying this ordinance really only does what Title VII does, okay, maybe it doesn't exceed and it's not preempted, but if it does anything more, then isn't it preempted? If it's doing more than what Title VII would allow?
Well, I would argue this. First of all, they've only made a facial challenge to the ordinance in this case, and don't they have to show that every application of this ordinance exceeds Title VII? More importantly, certainly this court, if it finds that there are applications which are invalid, the court can preserve the ordinance and excise those provisions which it finds invalid.
So how would you resolve then a conflict where federal law says that it's okay to ask for criminal conviction history, at least at a minimum, and then this ordinance that prohibits it?
I would respectfully disagree, Your Honor. I think federal law could potentially prohibit that, because if you consistently ask on the application about criminal history and you wind up deterring African Americans from being employed, you've committed a violation of Title VII. Now, in the instance that you cite, keep in mind that the ordinance still does not prohibit you from making a criminal record inquiry. It merely delays the process to enable or to encourage the employer to, quote, use their due diligence, as Director Funches said in drafting in this ordinance. So what we're trying to do there is basically the same thing, but again, in a different way. But it's not doing anything more than Title VII. It's not telling people you can't consider criminal history. It's using a tool to try to delay that consideration to give these folks a fair chance so that other factors, other attributes of the employees are being considered. You know, this isn't some kind of rogue ordinance. This isn't, with all due respect to Santa Cruz, California, we're not trying to ban nuclear weapons in the city of Waterloo. This is an ordinance that's been adopted by nearly 200 state and local governments, just as I think the ACLU pointed out in their brief. And I commend you to take a look at Exhibit 7, which the attorney Chris Wendland, who helped draft this ordinance, compiled, showing all the various cities across the country, similar ordinances and comparing them to Waterloo. This is hardly something that's in outer space or something that's
I mean, and nobody feels otherwise. If it was a question of how good a record have you made, you've made a very good record. But we still ultimately are driven by the language of 364.3 and 216.19. And I still come back to this question that it does seem to be a savings clause rather than affirmative authorization in 216.19.
Your Honor, let me go back, though, and maybe another point that might clarify that for you. Again, if you accept that argument, then you've got basically a clash between these two statutes, and you've got to resolve that. So that opens the door to considering legislative history. And lo and behold, that's what exactly happened in this case. When House File 295 was brought before the legislature in 2017, that's the bill that actually codified 364.312. The original draft of that bill deleted the very provisions we're talking about. In other words, it took away the savings clause. It took away 216.191C. But then the legislature, in its wisdom, passed H1107, an amendment which withdrew all that deletion. So it left 216.191C intact. And if you look, and I commend you to page 27 of the ACLU brief, in which they explicitly talk about the discussion the legislature had with respect to that amendment. And what happened was the legislature said to themselves, you know what? We're not going to go that far with 364.312. We're not going to impinge or interfere with local government's rights to enforce discriminatory or anti-discriminatory ordinances. We're going to back off on that. We're going to, in fact, one of the legislatures specifically said, we're going to keep the provision in place, allowing cities to pass further protection for protected classes. The wage and business component, though, is going to be, we're going to pass that. We're going to get that going through because that will complete its intended purpose. In other words,
doesn't that cut the other way? It seems like, from what you just said, the intention would be the legislature wanted municipalities to be allowed to legislate with respect to any protected class that it saw deemed fit to recognize, except for in the area of wages, hiring practices, terms and conditions of employment, which is why they left in the savings clause under 216.19.
2 points. Wage and business component, I think, refers to, and I can't remember who brought this up, minimum wage, not wage or in employment in the sense that you're saying, Your Honor. More importantly, if that's what's the legislature's intent, why didn't they just do this? It would have been very simple, and I think the NAAC points that out in their brief. Go right in there at 216.191C and say a city has the right to enact broader or different categories of discriminatory practices in the areas of accommodation, housing, education, or credit, and leave out the words employment, wouldn't that have accomplished the same exact result? They didn't do that. They left the statute intact. And if you accept the fact that somehow 364.312 preempts this, the 216.19, aren't you really just gutting that statute? Because there's no question the predominant form of discrimination, federal, state, local, is employment discrimination. I dare say that any commission will tell you 80, 90% of their cases involve employment. So if you take away employment, as you suggest, just employment, you've basically taken away local government's power to regulate discrimination anyway. And clearly,
Yeah, but
But that's
I'm going to,
extent that the discrimination is still actionable under the Iowa Civil Rights Act, the race discrimination provisions, then the statute doesn't take away enforcement authority. I mean, you said in your brief, footnote 5, this ordinance is coterminous with the Iowa Civil Rights Act. So everything you're talking about is already protected by other provisions of the law.
and I go back, but you still have taken away the power of a local governmental entity to use a different tactic to reach the same problem, because Waterloo faces a particular problem. It's nationwide, but Waterloo in particular has a problem. They have the most diverse population in the state in terms of minorities, 60% African American. There, as the ACLU cited, we were regarded as one of the third worst cities for African Americans to live. You're taking away the power of them to come up with a local remedy. Isn't that what home rule is all about? In other words,
You can wrap up, or I think Justice Apple may have had one question. Did you want to get your question in, Justice Apple?
yeah, I will briefly. Yeah, except the term hiring practice still appears within that statute. And you've got to give it some meaning. Do you not?
absolutely. I can give it a meaning fairly clearly, Your Honor. Let's take, for example, the city would pass an ordinance that said you can't hire a child unless he or she is at least 17 years old. Well, wait a minute. That would exceed state law, wouldn't it? Because, as the court's probably aware, there's various statutes that talk about 14, 15, 16. Isn't that a situation where right there a hiring practice is in fact prohibited by 364.312 that doesn't involve discrimination and gives the statute a definite meaning?
Thank you.
Thank you, Your Honor.
Mr. Koopmans, you may respond.
Thank you, Your Honor. I want to address just briefly the issue of the facial challenge and excising portions of it, just because this is kind of a theme that runs a little bit throughout the arguments back and forth, which is Waterloo cites often cases that deal with constitutional challenges to statutes or ordinances, while preemption is a constitutional matter because it is the power of the legislature to take away power from the cities whenever it wants to. I think Seymour used the word that the legislature has equal unfettered power to do so. So in that vein, it is a constitutional issue, but this court has never treated it and given those same kind of constitutional presumptions to it. So in this case, when you're talking about excising the statute or a facial challenge, we're not doing any of that. All we have to do is look at the statute. What the statute says governs. The statute doesn't just say that a city cannot enforce an ordinance to the extent that, or provided that. It says it cannot even enact an ordinance, and an ordinance that exceed, the provisions, the listed provisions. And in fact, for ordinances that were already on the books, it says that those are void. So this ordinance was void ab initio if it exceeded state or federal law. So I just want to inject that point in here, that we don't have those kind of same facial challenges and presumptions. And as this court pointed out in Griffion, the U.S. Supreme Court and this court it was a federal preemption issue. But when express preemption is at issue, not implied preemption, there is no presumption against preemption. The job of the court is simply to read the statute as best as it can to determine the intent of the legislature, because normally presumptions and constitutional issues are all about respect of the legislature as a co-equal branch of government of this body. The legislature has spoken on this, and now, and there is no, as some of the amici have said, some presumption or that these kinds of statutes, these reverse preemption statutes are bad. None of that matters here. The only thing is, what is the best interpretation that enacts the purpose, the legislature's purpose here?
Counsel, so has the General Assembly taken over the field from local entities related to hiring practices?
They have set the ceiling, yes. They have not, so, 216.9 sub 1 contains an A, which says that that cities can set up their own civil rights commissions and exercise that power. So they can still, I mean, the legislature, if it wanted to, could say there will be no enforcement at all on civil rights activities from a city or a human rights commission. Here, they can still pass ordinances that are coextensive with state and federal law, and they can enforce those.
What if the ordinance is consistent with state or federal law? Where does that fall in terms of statutes? Statutes, as you point out, says exceed or conflict. But if it's consistent with, is it okay?
Yes, if Waterloo had said, you may not consider criminal history in the hiring process to the extent that it causes a disparate impact and there is no business justification for it, which is parroting the Title VII standard, then that would not be preempted.
Does the ordinance have to exactly mirror that Title VII standard, or do we need to be a little bit more cautious in our approach? So let's take, for an example, the prohibition that an employer can't make a hiring decision based on expunged criminal records or convictions where it's been subject to a pardon or legally nullified. You could see potentially that might be a Title VII or ICRA disparate impact type case. Would that be allowed?
I don't know, and in fact, that's a unique provision where we have no statistics on the number, on the race of people who have criminal records and have had those expunged. So I have the statistics we have that are in the record about the general population and criminal history statistics. Those are there, and they show what they show, but we have no information on that particular issue. And if you look at the statute, there's often a discussion about business justification. That business justification component only applies to that last category. So under the ordinance, you cannot refuse to hire someone, and not just solely, but you cannot consider expungement at all. And to say that that is a Title VII violation or an Iowa civil rights violation per se is clearly wrong, and therefore it exceeds federal law and is preempted.
And that's maybe you can help me with that issue. I'm struggling a little bit with kind of how we navigate the exceed or conflicts language. So all the case law, we're really dealing with very case-specific facts, and what is the evidence in a particular case, the statistics, the labor shed, et cetera. In here, we're just kind of making a blanket wide class determination and applying it to all the employers in Waterloo. And maybe you'd have a Title VII case against some of them, and maybe you wouldn't. So I'm not sure how we judge the ordinance, given that fact pattern.
Facial analysis of the ordinance and facial analysis of the statute. The evidence of Waterloo and those criminal history is completely irrelevant for purposes of your preemption analysis. On the face of the statute, the ordinance, it bars employers from refusing to hire someone who has a criminal arrest record or criminal conviction that has been expunged in all cases. Title VII says not unless it causes a disparate impact. One is overbroad, it exceeds the other, therefore it is preempted. That's all you need, and it doesn't have to be any more complicated than that.
You may wrap up.
If there are no further questions, we ask that the district court order be reversed and that the ordinance be declared void. Thank you.
Thank you. The case of Iowa Association of Business and Industry versus City of Waterloo is hereby submitted. The next two cases are submitted without oral argument, Holmes versus Pomeroy and Williams versus Bullock. Court is adjourned.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.